Let me tell you something that happened in a quiet neighborhood that will make your stomach drop. A retired school teacher, 30 years in the classroom, dedicated her entire life to educating other people's children. She scrimped, she saved, she made her mortgage payments every single month for decades, and then finally, after all that sacrifice, she did it. She paid off her house completely. No mortgage, no debt, no monthly payment to anyone, just a home that was completely, totally legally hers. Or so she thought. Then one ordinary Tuesday morning, everything changed. Nobody broke down her door. Nobody threatened her. Nobody even called her on the phone. A complete stranger simply walked into a government office, handed over a single piece of paper, and walked out legally owning her house. And the worst part? The county stamped it, accepted it, filed it without a single question asked. No phone call to verify, no letter sent to the homeowner, no red flag raised anywhere in the system. By the time this retired teacher figured out what happened, she was already $4,000 in legal fees just trying to prove she owned the home she had lived in for decades. Months of stress, months of fear, months of fighting a battle she never should have had to fight. And here's the part that should make you genuinely angry. There was a free program, a completely free 5-minute program that would have sent her an email alert the same day the fraud happened. It existed the entire time. Her county offered it. Nobody ever told her about it. Not when she bought the house, not when she paid it off, not once in 30 years of owning that home. Here's the reality that nobody is talking about. If you own your home free and clear, you are not sitting in safety, you are sitting in the crosshairs. Your equity is visible right now in public records. Anyone with an internet connection can find your name, your address, your property value, and the fact that no bank has a lien on it, all in about 30 seconds. And most paid-off homeowners have absolutely zero protection in place against what can happen next. Today, I'm going to walk you through 5 specific documents that change everything. 5 documents that most retirees have never heard of, never filed, and never been told about. Most of them are completely free. All of them together take less than 1 afternoon to handle. And not having them is a risk that can cost you your home, your savings, and years of your life fighting to get it back. This is general educational information only. Always consult a qualified professional for your specific situation before making any decisions. Welcome back to Bullion Fracture. Subscribe and hit the bell icon. Let us get into it. Document number 1, the Homestead Declaration. Let me ask you something. Have you ever heard of a homestead declaration? If you are like most homeowners, the answer is no, and that is not your fault. It is one of those things that wealthy people know about because they have attorneys who handle it automatically. For everyone else, it simply never comes up. So let me explain exactly what it is and why it matters so much. A homestead declaration is a legal document you file at your county recorder's office that puts a wall around your home equity. A real, legally enforceable wall. Once it is filed, unsecured creditors cannot reach that protected equity. We are talking about medical debt collectors who got a court judgment against you. Civil lawsuit winners who are now coming after your assets, credit card companies that sued you and won a default judgment, personal loan recovery firms, all of them legally blocked from touching the equity inside that wall. Think about how exposed you are right now without it. One serious medical emergency, one car accident where someone sues you, one business deal gone wrong, one slip and fall on your property where someone decides to take you to court. Any of these situations could result in a judgment that allows a creditor to attach a lien to your home that you spent 30 years paying off, your home that was supposed to be your retirement security, gone, or at least seriously threatened because of one event you never saw coming. The Homestead Declaration stops that from happening. Now, the numbers vary depending on what state you live in. Florida and Texas offer the most powerful protection in the country. Both states protect unlimited equity on your primary residence. That means if your home is worth $1 million and it is your primary home, no unsecured creditor can force a sale to collect on their judgment. None. Zero. Your equity is completely untouchable. California protects between $361,000 and $722,000 depending on your county's median home price. Massachusetts protects up to $1 million for homeowners over the age of 62. Ohio protects $182,725. Nevada protects $65,000. Some states offer as little as $5,000 in protection. But here's the thing. Even $5,000 of protection is infinitely better than zero. And in most states, the number is significantly higher than that. Here is what the Homestead Declaration does not do. This matters. It does not stop your mortgage lender from foreclosing if you stop making payments. It does not stop the IRS from collecting on a federal tax lien. But those are different situations with their own rules, and I will talk about the IRS specifically in just a moment because it is critically important. But for the overwhelming majority of financial threats that retirees actually face day to day, the Homestead Declaration is your first and most powerful line of defense. One page, notarized, filed at your county recorder's office, free in most states, takes about 30 minutes of your time. When a wealthy person buys a home, their attorney files this document before they even leave the closing table. It is not optional. It is not a discussion. It is just done automatically as part of the process. For everyone without an attorney managing their affairs, this document simply never gets mentioned. Go to your county recorder's website this week, search for Homestead Declaration, download the form, fill it out, get it notarized at your bank or UPS store for usually $10 or less, file it at the recorder's office, done. 30 minutes, potentially hundreds of thousands of dollars in protection. This is document number 1, and it is the foundation that everything else builds on. Document number 2, the property. Fraud alert registration. This is the document that would have saved that retired teacher in Clark County from every single dollar of legal fees and every single sleepless night she endured. And I want you to really understand how this fraud works before I tell you the fix. Because once you understand the mechanics of it, you will never put this off. Here is exactly how property deed fraud happens, step by step. A scammer sits down at a computer. They go to your county's public property records database. It is free. It is online. It takes about 30 seconds to search. They are specifically looking for properties that are paid off, meaning no mortgage lender has a lien on record. They are also looking for owners who appear to be older, because older homeowners with paid-off properties are statistically the most valuable targets and often the least likely to be monitoring their property records closely. They find your house, they see your name, they see the equity sitting there with no lender protecting the ownership chain, and they get to work. They create a forged deed. They put your name as the grantor and either their name or a fake name as the grantee. They make it look official. Then they walk into your county recorder's office and hand it over. And here is the part of the system that is genuinely broken. In most counties across America, documents are filed first and verified never. The recorder's office is not a fraud investigation unit. They are a filing office. Their job is to accept documents and record them. They do not call the previous owner to confirm. They do not cross-reference signatures. They stamp it, file it, and move on. Your home is now, on paper, owned by someone else. The scammer then has 2 options. They can approach a hard money lender and borrow against your property, walking away with cash using your equity as collateral. Or they can actually try to sell your home to an unsuspecting buyer. Either way, by the time you discover what happened, real money has moved and real legal damage has been done. You're now spending thousands of dollars and months of your life in court just to prove you own your own home. The fix is almost insultingly simple, given how serious the problem is. Most counties in America now offer a completely free property fraud alert program. You go to your county's website, you search for property fraud alert or property owner. Alert! You enter your name and your property information. You click submit. That is it. The whole thing takes about 5 minutes. From that moment forward, every single time anyone files any document against your property, you receive an email notification within 24 hours. A deed, a lien, a transfer, anything. You get an email the same day it happens. That one email would have saved the Clark County teacher everything. She would have seen the alert, called the recorder's office that afternoon, flagged the forged deed, and the nightmare would have been stopped before it ever became a real problem. Your county already has your information. They already know you own that home. They have your address. They have your name. They have had it for years or decades. They have never once proactively reached out to tell you this free service exists. Not one letter, not one phone call, not one automated email. That is why you have to go find it yourself. Search your county name plus property fraud alert or property owner alert this week. Sign up today, 5 minutes, 0 cost. This is document number 2, and it is the early warning system that makes everything else work. A critical warning before we continue. The IRS situation. Before I get to document 3, I need to stop and address something that most videos on this topic completely ignore. And ignoring it is a mistake that can cost you everything, even if you have done all 5 of the other things perfectly. The IRS. Everything I just told you about protecting your equity from creditors through the Homestead Declaration, the IRS does not care about any of it, not one bit. Federal tax liens exist in an entirely different category from unsecured creditor judgments. A federal tax lien overrides your homestead protection, full stop. It attaches to every single asset you own, including your home, the moment you owe taxes, and fail to respond to IRS notices. And for retirees, the situation happens more frequently than most people realize. Here is how it sneaks up on you. You miss an estimated tax payment because your income situation changed after retirement. You do a Roth conversion, and you forget to set aside money for the tax bill that comes with it. You receive a lump sum Social Security payment that unexpectedly pushes you into a higher tax bracket, and you did not adjust your withholding to account for it. The IRS sends you a bill in the mail, you set it aside, meaning to deal with it later. Then you set it aside again, 6 months pass, a year passes, and now there's a federal tax lien filed against your home. Once that lien is on record, it becomes public. It damages your credit. It makes it nearly impossible to sell or refinance your property without paying the IRS first, and it completely bypasses every other protection we are talking about today. The solution is not complicated, but it requires discipline. Stay completely current on your taxes. Open every single piece of mail that comes from the IRS the day it arrives. If you discover you owe money, contact the IRS immediately and set up an installment agreement. An installment agreement keeps the IRS from escalating to a lien as long as you're making your agreed payments. If you already have a lien in place, work with a qualified tax professional on getting it released or subordinated. The 5 documents in this video build a powerful wall of protection around your home, but none of them matter if the IRS is already standing inside that wall. This is the foundation that has to be solid before anything else works. Document number 3, the Enhanced Title Insurance Policy. When you closed on your home, you received a title insurance policy. You probably remember signing a stack of papers that thick, and somewhere in that stack was a title insurance document that you signed without reading because you were exhausted and just wanted to get the keys. Most people are in exactly that situation. And most people ended up with a standard policy without ever knowing there was another option on the table. Here's the critical difference between standard and enhanced title insurance and why it matters so much right now. A standard title insurance policy protects you from problems that existed before your closing date. Hidden liens from a previous owner, forgery or fraud that happened in the ownership history before you bought the house, claims from heirs of a previous owner who was not properly included in a sale. These are all real risks, and standard coverage handles them well. But the moment you sign on closing day, your standard policy stops looking forward. Anything that happens after closing is simply not covered. If someone forges a deed on your property 6 months from now, your standard policy does not touch it. If an identity thief transfers your title through a fraudulent conveyance next year, you are completely on your own. And the legal cost to fight that kind of fraud can run from $20,000 to $40,000 or more, depending on how complicated the situation becomes and how long it takes to resolve. An enhanced owner's title insurance policy changes that equation entirely. It faces forward. It covers forgery of documents that happen after your closing date. It covers identity theft transfers. It covers fraudulent deed conveyances that occur in the future. And critically, it covers your legal fees to fight these situations when they arise. Think about what that means in practical terms. If the exact same fraud that happened to the Clark County teacher happened to you, an enhanced policy would pay for your attorneys to fight it. It would cover the legal costs of proving your ownership. You would not be out of pocket $4,000 or $40,000. The insurance would handle it. Now I want to be straightforward with you. This one is not free. Upgrading from standard to enhanced title insurance costs money. The exact amount depends on your property value and your state. But the question is not really about the upgrade cost. The question is about what you are comparing it to. Here's what I want you to do this week. Pick up your phone and call the title company that handled your closing. Ask them 2 specific questions. First, is my current policy standard or enhanced? Second, if it is standard, what is the cost to upgrade to an enhanced owner's policy? 1 phone call, 5 minutes of your time. If the answer to that second question saves you $40,000 in legal fees at some point in the future, it will be the most valuable 5-minute conversation you have ever had. This is document number 3. Document number 4, the revocable living trust. Here is something most people never think about. Right now, if anyone in the country wants to find out that you own your home, that you paid it off and roughly what it is worth, they can do that in about 30s seconds using free online property records. Your full name is attached to your property. The absence of any mortgage line is visible. The assessed value is right there. To a scammer running searches looking for elderly homeowners with paid-off properties, your home is basically wearing a flashing neon sign that says Easy Target. A revocable living trust quietly turns that sign off. Here is how it works. When you transfer your home into a revocable living trust, the ownership in the public property records shifts from your personal name to the name of the trust. Something like the Johnson Family Living Trust instead of Robert and Margaret Johnson. Your personal name is no longer the searchable owner of record. You still own everything. You still live in your home exactly as you always have. You still make every decision about the property. You can still sell it whenever you want. You can still modify the trust whenever you want. Nothing about your daily life changes at all. The only thing that changes is what shows up in a 30-second public records search. And that one change makes you significantly less attractive to the scammers who are specifically hunting for personal names attached to paid-off properties. They are looking for easy targets. A trust-owned property does not look like an easy target. It looks complicated, so they move on. But the fraud protection benefit is actually the secondary benefit of a living trust. The primary benefit is what happens when you pass away. Without a trust, your home goes through probate. Probate is a court-supervised legal process for transferring assets after death. It is public record, it is slow, often taking 6 months to 2 years to complete. And it is expensive, typically costing 3 to 5% of the total estate value in attorney fees, court costs, and administrative expenses. On a $500,000 home that is up to $25,000 taken out of what you are leaving your family before they see a single dollar. With a properly funded living trust, your home transfers directly to your heirs the moment you pass away. No court process, no public record, no waiting period, no percentage of the estate eaten up in fees. Your family gets what you built for them quickly, privately, and completely. Setting up a revocable living trust with an estate planning attorney typically costs between $1,000 and $3,000, depending on your state and the complexity of your situation. Compare that $2,000 investment to potentially $25,000 in probate costs, and the math is not complicated. Now, there is one thing I need to be very clear about, because this is where people make an expensive mistake. A revocable living trust does not protect your assets from creditors while you are alive. That is not what it is designed to do. That is what the Homestead Declaration in Document 1 handles. The trust and the Homestead Declaration do completely different jobs, and you need both of them working together. And if you already have a living trust, please do this right now. Call your attorney and confirm that your home is actually titled in the trust's name. I cannot overstate how common it is for retirees to have a beautifully prepared trust document sitting in a filing cabinet somewhere, but the deed to their home was never actually transferred into the trust. The trust only protects and transfers what is legally inside it. If the deed was never transferred, the trust does nothing for your home. Verify this with your attorney this week. This is document number 4. Document number 5. The tax redemption and senior exemption records. In 2023, a case called Tyler versus Hennepin County went all the way to the United States Supreme Court. And the story behind it is one that every homeowner over the age of 60 needs to hear and remember. Geraldine Tyler was 94 years old. She lived in Minnesota. She fell behind on her property taxes, owing approximately $15,000 in back taxes and penalties. The county followed their legal process. They seized her condominium. They sold it at auction for $40,000. They kept the $15,000 she owed them. And then they kept the remaining $25,000 too. $25,000 of equity that belonged to Geraldine Tyler. Equity that represented a significant portion of everything she had. The county's position was that their statutes allowed them to keep the entire sale proceeds beyond what was owed. All 9 Supreme Court justices disagreed. Unanimously, they ruled that taking more than what was owed was unconstitutional. The county had to return the surplus equity to the homeowner. The ruling changed the law across the country. States are now required to return surplus equity after a property tax forfeiture sale. Your equity beyond what you owe in back taxes cannot be legally seized. But here is where it gets deeply uncomfortable. States are implementing this ruling at dramatically different speeds. Some states have fully updated their statutes. Others are partially updated. Some have barely started the process. And in every state, the redemption window, meaning the period of time during which you can pay your back taxes and reclaim your property before it goes to sale, still has a hard deadline. If you miss that window, you lose your chance. And most people who need to use it find out about it after the deadline has already passed. For retirees, this risk is particularly real. A spouse passes away unexpectedly, and the surviving partner, now managing finances alone for the first time, misses a property tax payment. A serious medical event drains savings and the tax bill gets pushed aside. These situations happen constantly, and the county's timeline for moving from delinquency to seizure can move faster than people expect. Here is what you need to do right now regarding this document. Know exactly what your county's process is for property tax delinquency. Know the timeline. Know the redemption window in your state. And if you ever receive a tax delinquency notice, treat it like the emergency that it is and respond the same day you receive it. Do not set it aside. Do not assume you have time. Respond immediately. Now here is the piece of this that could actually put money back in your pocket starting right now. Almost every state in America offers a senior property tax exemption that reduces your annual property tax bill. These are not small discounts. In Texas, the over 65 homestead exemption can reduce your property's taxable value by $200,000 or more, which translates to hundreds of dollars saved every single year. Florida completely freezes your property tax assessment once you qualify, meaning your taxes cannot increase even as your home value rises. Georgia offers seniors over 62 a full exemption from school taxes, which typically make up the largest portion of a property tax bill. New York just expanded its senior exemption to cover up to 65% of assessed value starting in 2026. These exemptions are not automatic. Nobody applies them on your behalf. Nobody sends you a letter telling you that you qualify. You have to find them and apply for them yourself. And in many states, the application deadline for the 2026 tax year is April 30th. If you turned 65 3 years ago and you have never applied for your senior exemption, you have been overpaying your property taxes for 3 full years. That money is gone, but you can stop the overpayment starting right now. Call your county assessor's office this week. Ask them what senior exemptions are available and what the application deadline is. This is document number 5, and it is the one that can both protect your home from tax seizure and reduce what you owe every single year going forward. Let me bring everything together for you because you deserve a clear action plan you can actually use. 5 documents, 1 afternoon. Here's exactly what you do. First, go to your county recorder's website and search for Homestead Declaration. Download the form, get it notarized, file it. Free in most states, 30 minutes. Done. Your equity now has a legal wall around it, protecting it from unsecured creditors. Second, go to your county's website and search for Property Fraud Alert or Property Owner Alert. Sign up with your name and property information. Free. 5 minutes. Done. From this moment forward, you get an email within 24 hours anytime anyone files anything against your property. Third, call your title insurance company this week and ask whether your current policy is standard or enhanced. If it is standard, ask what an upgrade to an enhanced owner's policy costs. 1 phone call. 5 minutes. This one conversation could save you $40,000 in legal fees down the road. Fourth, if you do not have a revocable living trust, contact an estate planning attorney and have one created and funded properly. If you already have a trust, call your attorney today and confirm that your home deed is actually titled in the trust's name. Do not assume. Verify. Fifth, call your county assessor's office and find out every senior property tax exemption you qualify for and the deadline to apply. Then apply before that deadline. And know your county's property tax delinquency timeline so you are never caught off guard. That is the complete picture. 5 documents, most of them free, all of them together protecting you from the 3 biggest threats to your home equity: scammers, creditors, and the government. Here is the honest truth about all of this. The gap between the retiree who keeps everything they built and the one who loses it is almost never about how much money they had. It is almost always about whether they knew these 5 things existed and took the 2 or 3 hours required to handle them. The retired teacher in Clark County was not careless. She was not foolish. She was just never told. And the system that failed her is the same system most homeowners are relying on right now without even knowing it. You know now, so handle it. If this helped you, please share it with someone you know who owns their home, especially if they are retired or getting close to retirement. Drop a comment below and tell me which of these 5 documents you are taking action on first. I read every comment, and the situations you bring up shape what I cover in future videos.